Preparing case laws forms an important portion for UGC NET exam. Since 2022 attempt is approaching and it might take place in the month of June, so you must be preparing well now. Hello everyone and welcome to UGC channel. So here in this video, I'll present list of some crucial judgments under patent law relevant for NET exam. Firstly, let's know that what is patent. Patent is a statutory right granted for invention, and that invention could be a product or a process, provided that they satisfy the three grounds. That it should be novel, it involves inventive steps, and must be capable of industrial application. This is what the patent is. Now, let's start with the case laws. So our first case is Bayer Corporation versus Union of India. And this case is based on the concept of compulsory licensing. What is compulsory licensing? So it occurs when a government authorizes an organization other than the patent owner to produce a patented product or a process without the owner's consent. The patent owner is remunerated for the license but doesn't have the option to refuse the license or select the licensee or determine royalty rates. So that is why it is known as compulsory licensing, and it can be only applied only after the expiry of 3 years. So in this case, there was a company named Bayer Corporation, and it is a US based company, and got its anti-cancer drug named Nexavar patented in India in year 2008. And after this, an application for compulsory license was filed by Natco Pharma, the other company. The Natco applied to the controller after an expiry of 3 years, as it has been mentioned under Section 84 of Patent Act. And when the matter went before the Apex Court, the grant of a compulsory license was sanctioned. So in this way, the judgment became the first case where a compulsory license was issued after India became a signatory to TRIPS and also to the Doha Declaration in 2001. Second case is Monsanto versus Noziwido, popularly known as the BT Cotton judgment. So here in this case, a company named Monsanto was licensing its BT products to various Indian seed companies, including Noziwido and its subsidiaries. The issue was regarding the patent infringement, where the Monsanto claimed that NAS, on which the company got patent, is a microorganism and hence it should be patentable under the Act. But when the matter went before the Delhi High Court, it held that the invention wasn't patentable subject matter under Section 3 Clause J of Patent Act, but was more suitably protected under the Protection of Plant Variety and Farmers' Right Act. Now after this judgment, both parties appealed the decision to the Supreme Court. Now when the matter went before the Supreme Court, it held that the question of validity of a patent is a mixed question of fact and law, and therefore evidence and expert testimony were to be considered. And in this way, the Supreme Court remanded the matter to the Delhi High Court, and still the matter is pending. The third case is Feridalani versus Union of India, and in this very case, the eligibility of computer-related inventions under the Patent Act was discussed. So if you refer Section 3 Clause K of Patent Act, you will notice that the computer program per se is not patentable. Though computer programs or the software programs, they are protected under the Copyright Act, but not under the Patent Act. So now when the matter went before the Delhi High Court, the Delhi High Court has heavily relied on the guidelines for the examination of computer-related inventions, which was released in year 2017, and according to which these kind of inventions that demonstrates technical effect or technical contribution, they will fall under the patentability. Or in the simpler version, the computer program or the computer inventions that have got the technical effect or technical contribution, they will be provided patent. Our last case is Novartis versus Union of India, in which the company named Novartis filed a registration of patent application for one of its drugs called as Glivec under Section 3 of Patent Act. But the Supreme Court rejected the application of Novartis after a period of 7 years long battle. The reasons cited were that there was no invention of any new drug, and a mere discovery of an already existing drug will not amount to an invention under the Patent Act. Hence, For the grant of pharmaceutical patents in India, apart from proving the traditional test, there is a new test of improved therapeutic efficacy for the claims that cover some incremental changes to an already existing drugs, which the Novartis drug didn't qualify. Moreover, the Supreme Court has emphasized the importance and the true intention of Section 3 Clause D of Patent Act, where it was to prevent the concept of evergreening. And thus, if the invention doesn't fulfill the test of Section 3 Clause D, it cannot be granted a patent. Hence, these were some important judgments under the patent law. Thank you for watching this video. Please like and share this video with your friends, and do subscribe Jury Search Academy to get the further updates.